Have you graduated high school?
No, sir.
No, you haven't even graduated high school and you're facing a life offense. And then somebody just gives you some simple rules to follow, some simple things not to do. And you can't do that. You can't follow your mother's rules. You can't follow the court's rules. You can't follow any rules. So you tell me why, if you're just going to throw away your life, why I shouldn't just lock you up right now?
No.
You tell me why.
Improving, sir. And
Improving how? You're smoking last night. Tell me how that's an improvement.
This opening exchange immediately sets the tone, and Judge Simpson wastes absolutely no time establishing the gravity of the situation. From a legal standpoint, what we're seeing here is not just frustration. It's a judge evaluating risk, credibility, and compliance. The court isn't punishing the defendant for being young. It's reacting to repeated rule-breaking while already under court supervision. That's critical. When someone is out on bond, especially a PR bond, the expectation is strict compliance. The judge is essentially saying, you've been given leniency. Why should that continue? Notice how the judge frames this as a pattern: not following school rules, not following parental rules, not following court rules. That matters because bond decisions are forward-looking. The court isn't just asking what happened, it's asking what's likely to happen next. And from the judge's perspective, the answer looks bleak. Here's the real question for viewers. Should age and potential still outweigh repeated violations? Or does responsibility have to come first, no matter how young you are? This is the moment where the entire case pivots, because what happens next determines whether the court believes rehabilitation is possible outside a jail cell.
I don't, and I'll be honest with you, I went through the bond form, Mr. McGoes. I don't understand how he has a PR bond. I don't. And again, I don't know your mom, but you got these charges come up, you got your mom scared to death.
And I just asked if you do make a bond, can you make it affordable for me? It's just me. And then I've been missing work already. I've missed almost a month. They're on me. I got to go meet with my HR on Monday about my job. This is so hard. And I told him I was only messing up at work because of this. I can handle it.
Okay.
I'm sorry.
No, do not apologize.
I'm so sorry.
What I'm going to do is I'm going to revoke your bond. You sit there and you think about it. I'm going to set a bond hearing 4:00 on Monday, 4 p.m. But what you're going to do, young man, since you can't seem to understand what kind of life you're kind of headed to, you ever been in jail?
yeah,
For how long?
they put me in here for 4 days.
On this
Okay.
case, Judge.
Well, you're going to be back in. And then when come Monday, you might just stay in. You have nobody to blame for this but you. So at this time, defendant is remanded. Set this hearing, and the defendant is present. I set this hearing after the court finding a bond violation and had revoked the defendant's bond. I set this hearing giving an opportunity for reconsideration of that bond issue.
This segment is where the legal mechanics really matter. A bond violation finding triggers a two-step process. First, revocation. Second, possible reconsideration. Judge Simpson explicitly states this hearing exists to give the defendant another chance to argue for release. That's due process in action. Defense counsel immediately pivots to mitigation. Family support, first offense, academic history, juvenile dismissal. These are classic bond reinstatement arguments, and they're not weak arguments. Courts absolutely consider first-time status and family supervision. But the prosecution raises a crucial concern. The violation happened in the same environment the defendant would return to. That's a powerful argument against release. Legally, bond conditions must be realistic. If school access leads to drug exposure, the court has to ask whether the condition itself is setting the defendant up to fail. That's why GPS tether, testing regimens, and structured supervision are discussed here.
Thank you, Judge. Your Honor, I'm in the courtroom today with my client's mother, Nicole Barrow, His brother, Uncle Gino's in the courtroom, as well as Gino Jr., as well as Raymond Spears.
Okay, you just gave me three. I have no idea who that Gino
Yeah.
is.
Sorry, Reno. And Raymond Spears is his old football coach. They're all here in support of young Mr. Smith. Your Honor, we were here last Thursday and it was a PCC, Your Honor, requested, asked the people requested to amend the bond and change it from a PR bond. We discussed it a little bit, and then Your Honor asked Mr. Smith whether he had been using marijuana, and he honestly said that he was, and Your Honor revoked his bond. We're here today.
Well, it was kind of like that. I asked him, would he pass a drug test?
Correct. Thank you, Judge. To remind the court, this is young Mr. Smith's first criminal charges lifetime. He has a perfect record at school. He was on his way to 4.0 grades until last semester when his grades declined. It is no coincidence that he has now, that's when his problems with the law began. He was not attending his duties at school. He was sort of hanging out with the wrong crowd, not to justify or offer an excuse, but here we are today. It was charged originally, this case that is in front of us was charged in juvenile court. He spent 4 days in custody. After that, he was released from custody. We went in front of the juvenile court judge and the case was dismissed, and then he was charged in adult court. The charges are very serious. I can approach and we can discuss a little bit about the biggest charge if Your Honor would like to hear. I believe he has there are compelling defenses to that. The short of it is we're seeking to have him placed back on his house arrest tether, so he can go to school, so he can go to church, so he can do the right thing and be around his family and have the support of his family and handle these cases on all fours. He is presumed innocent. This is a good young man. I have faith in this young man, and I'm here for the duration.
Anything from the people?
Your Honor, people already stated their position on Thursday. The only thing that I have to add from that previous argument is that I do have some concerns being released under the same or similar conditions as before of the GPS tether with allowances for church and school. I believe the defendant stated at the last hearing that he got the marijuana from school. And so I'm concerned about releasing him and then putting him back in the same environment where he got the marijuana that led to this violation in the first place. Thank you.
I would just suggest the court may, if Your Honor was inclined to reconsider, may institute a testing regimen would be something this young man should be responsible to and could handle.
Well, and I appreciate what the people are saying. The other issue in this one that plagued me since I put him in, and those of you that know me know that it would, and that is that if he stays incarcerated, maybe that might be the right decision for most. What I then know is he doesn't graduate. And then at the end of it all, I don't know what we have. That's the bottom line to it.
This is one of the most revealing moments of the entire hearing. Judge Simpson openly wrestles with the unintended consequences of incarceration. That's rare and important. The court is acknowledging that jail can sometimes prevent growth instead of encouraging it. Graduation matters legally because it's a stabilizing factor. Courts view education as a predictor of reduced recidivism. But here's the tension. The defendant hasn't proven reliability yet. The judge is weighing two risks, release risk versus incarceration damage, and neither option is clean. This is where judicial discretion becomes human, not robotic. This is also where accountability starts shifting back to the defendant. The court asks, what have you been thinking about while locked up? This isn't therapy, it's assessment. Is the reflection real or rehearsed? Judges hear thousands of promises. They look for specificity, consistency, and follow-through.
Young man, what? So when you spent the 4 days before, that was in a juvenile facility?
No, it was here in a holding cell.
They didn't, for some reason, they weren't able to hold him in the juvenile facility, Judge.
So what have you been thinking about?
Like recently,
Well, you got locked up on Thursday. Now, unless your mind shut down, what have you been thinking
I've been thinking about first how right you were, and that I did learn my lesson, and that my actions do have consequences, and then this is a very serious matter, and that I do not want to be here, and not, it's more like this place shows me that I'm not supposed to be here, and that like
What you were telling me earlier today.
and that I've been thinking about, going to school. I've been thinking about graduating to go to college. I've been thinking about my relationship with God, and that how I can become a better person, and that sorry, Your Honor. And pretty much like how I can improve myself as a better person. And that's what I've been practicing while I've been there. And so I can, when I'm out, I can become a better person, I can show you, not with just my words, but with my actions.
This is the defendant's most important statement so far, and also the most dangerous one if it isn't backed up. Courts treat this phrase with extreme skepticism because it's commonly repeated. What makes or breaks credibility is evidence, grades, attendance, clean tests, structure. Judge Simpson immediately drills down on academics. Why? Because grades are measurable. You can't fake them. And when the defendant admits there's a C on the record, the judge responds sharply. That's not cruelty, it's expectation setting. The court is signaling. Excellence is the minimum requirement for continued freedom. From a legal perspective, this is conditional liberty. The judge isn't offering freedom, he's offering earned compliance. This is probation logic applied at the bond stage, and it comes with a warning. Failure means immediate remand, no second hearing.
Why are your grades slipping?
Well,
Because see, here's the thing. If I were to reinstate your bond, put you back out there, problem's going to be is that if you're failing out of school, my major motivation for even giving you that opportunity isn't there.
On your grades.
okay, yeah. Well, yeah. So, ever since I've been out, my grades has been improving. I have screenshots to prove that I have A+ right now. My lowest grade right now is a C. I believe a C.
In what?
A C in 1 second, Your Honor. I'm trying to think. I have an A+ in accounting too. A C in newspaper. It's a newspaper entertainment. I had to miss an assignment that I haven't turned in.
What should your grades be?
All A+, Your Honor. Or at least passing. Or not at least passing, but A's and B's. But I'm shooting for all A's.
And you shouldn't even be thinking, there shouldn't even be a C on any. Mom, anything you want to say?
Please step up.
You'll have to stay right there.
Oh,
Thank you. I have signed us up in counseling, for Thrive Works in Ann Arbor for not just him, but for family. Also, I looked into him being into a mentorship program. Along with his football coach, started a program called Pathways to Careers. And he said he'd be willing to mentor him along with his older brother who's starting U of M in the fall for software engineering, and his uncle. I got them in their lives, and then now I have more time off from work to be able to, they understand what's going on, to be able to get him on the right track. And that's my goal. If I gotta monitor him, take him to school, be there. I got engaged with the teachers. They just assumed that he had been ill, so they've been allowing him to make up the work. His grades have come back up. They're all missing him. He's well liked in his whole school, principal, everybody. They've known him since elementary. When we came up here, he was in the 5th grade. And I make sure that he's no contact with them now. Taking his phone. He doesn't have it. I have a new number. And I actually have it linked to my iCloud, so I'm able to view all of his activities through my cell phone.
This is where the emotional weight shifts dramatically. The mother steps in, and suddenly this case stops being abstract. She outlines supervision, mentorship, monitoring, and sacrifice. Legally, parental oversight can be a decisive factor in bond reinstatement if the court believes it's real and enforceable. But Judge Simpson doesn't let emotion override reality. He reframes the issue as respect for the mother, the court, and self. Judges often view disrespect as a predictor of future noncompliance. That's why this line of questioning is so intense. The judge's statement about the mother not sleeping is more than commentary. It's judicial insight. Courts see families collapse under the weight of repeated violations. This is the judge saying, your actions don't just affect you.
You're hanging around a bunch of grown men. Maybe,
Yes.
right?
It was a mistake.
So when you went to jail, did you feel grown? Because I can there's a whole lot of grown folks back there if that's what you want to be. You know something? Do you remember what I told you about respect on Thursday? Or did your head just shut off at some point?
No, I remember, Your Honor.
What did I tell you?
Tell me respect. It's like, oh, sorry. Yeah. Yeah, you told me to respect my mother, and that if I can't respect my mother or the court, then that's a problem. And I do remember, Your Honor. And I would like to say that I am, like, these 4 days, it may seem little, but it was a lot to me. And I really, like, had time to think about it and on respect and the lengths that my mother is going for me. And the least I can do is to respect her to my full extent.
You know what's funny? I mean, I hear you, and to the extent you can understand it, you understand it, but you're never, until you are one, going to ever understand the sacrifice of a parent. You're just not, you're not going to get it. Because I don't know if you slept while you were there, but she probably hasn't slept the moment I put you back there. You didn't see. I mean, she knows they're serious charges, but you did not see your mother's reaction when I said, and I'll admit I was kind of yelling at you, that you're facing light. And I saw your mother's reaction. Because no matter what it is, no matter what's going on or anything, no matter how stupid you get, you're still her baby. If you can't respect her, and I told you this, you need to respect the court orders, you need to respect your mother, you need to respect yourself. But I've been doing this a long time, and I figure somebody that can't respect their mother, you know, probably shouldn't be out there walking around and doing anything.
This line is brutal and intentional. Judges often use blunt language when they believe subtlety has failed. From a legal standpoint, respect correlates with compliance. The court isn't moralizing, it's predicting behavior. The judge ties respect directly to safety. If you can't follow household rules, how can the court trust you with legal ones? This logic underpins many bond revocations nationwide. It's not about punishment, it's about risk mitigation. At this point, the defendant is on a razor's edge. One wrong answer, one deflection, and incarceration becomes permanent. The judge is testing maturity under pressure. Ask yourself honestly, is this tough love justice necessary, or does it cross into intimidation? Courts walk that line constantly, especially with young defendants.
Man, you took time out. What were you talking about work?
My health isn't so good. I can't figure out. I've been on a trial study once in a while. My lungs. I don't smoke or anything. They don't know. I've been seeing a pulmonologist. And
So you're just off. So right now you're off of work.
Yes. It's not because of him. It's my health. It's before that.
Yeah, but him doing what he's doing can't help.
So he just cleared the I've never had any issues about it. So this is why it's a shocker. All a shock, all of us. We all are shocked.
Your school on a 4-point schedule?
Sorry, I don't understand.
What's the highest grade point you can get? Is it 4 or 5 or 4?
I think 4.0. 4.0 is the highest you can get.
It is over the objection of the people. I'm not going to put a cash component on it at this point. I'm going to reinstate this previous bond with conditions that you're to test 3 times per week. Anything show up in your system, young man, you're going back. I'm not having a bond here. I'm just going to revoke. You are also to work your way. I want to see a 3.5 grade point average or above.
This is conditional mercy at its strictest. The bond is reinstated, but with zero tolerance. Drug testing 3 times a week is aggressive supervision. A 3.5 GPA requirement is unusually high, signaling the judge expects excellence, not survival. Legally, this is the court crafting a final opportunity. There is no buffer, no warnings, no second chances. Any failure triggers automatic revocation without hearing. That's a powerful incentive structure. Judge Simpson also removes the cash component, which indicates this decision isn't about money, it's about behavior. Freedom here is earned daily, not granted once. Audience engagement. Do you think this level of supervision sets the defendant up for success? Or is the bar set so high that failure becomes inevitable? This is the experiment the court is now running.
Hear me?
Yes, Your Honor.
So if this case is still before me and as you approach graduation and you're not near that 3.5, you know where you're going to go? Right back. Because what that just tells me is you're not applying yourself. Is there anything you're unclear about?
No,
You understand very clearly, I hope, that this is not a game.
Yes, Your Honor, I understand.
All right. To the extent you think it's a game, you don't want to play that with me. We clear?
Yes, Your Honor.
Probable cause conference, March 6th.
Thank you, Judge.
Thank you, folks.
Good luck.
Welcome.
You got a chance.
This case ends with clarity, not comfort. Judge Simpson reinstates bond, but only under the strictest possible terms. The ruling sends a broader message. The court believes in rehabilitation, but only when it's earned through discipline, respect, and measurable progress. The legal takeaway is clear. Bond is a privilege, not a right. Honesty alone doesn't protect you. Compliance does. Education, supervision, and accountability became the deciding factors, not sympathy. This young defendant now carries the full weight of his future on daily choices. For the justice system, this ruling reflects a balancing act between protecting society and salvaging potential. For the defendant, it's the final off-ramp before incarceration becomes permanent. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.